the man?
He's here somewhere. He'll be here. He'll be here any minute.
I didn't see any flash.
You will when he walks in.
I mean,
I haven't seen him yet either. so
That's right.
What's he wearing today?
All right, good morning, everybody. This meeting of the Escambia County Planning Board for June 3rd, 2025 is hereby called to order with 7 members present. We do have a quorum. Just a reminder, please turn off your electronic devices or put them on silent. If you would, please stand with me for the Pledge of Allegiance. All right, thank you. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning meeting minutes from the previous meeting dated May 6th has been provided to the board members. Are there any additions, deletions, or corrections? If not, I'll entertain a motion.
So moved.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning hearing package for June 3rd, 2025 with findings of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into evidence. Do I have a motion?
So moved.
A second?
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries. Will the court reporter please swear in members of the staff?
Everyone raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right. And we have previously, the board has qualified staff as expert testimony in the area of land use and planning. Do any board members have questions regarding their qualifications and ability to offer expert testimony today? All right. At this hearing, the planning board is acting under its authority to hear and make recommendations to the planning board, to the Board of County Commissioners, the BCC, on rezoning applications. These hearings are quasi-judicial in nature. These hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, the exhibits entered into evidence, and the law. Each individual who wishes to address the planning board must complete a speaker request form and submit it to the planning board clerk. These forms are found on the back of the table, or the back of the room on the table there. You will not be allowed to speak until we receive a completed form. And please note that only those individuals who are present and give testimony on the record at this hearing before the planning board will be able to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented at the Board of County Commissioners meeting. Therefore, all testimony and evidence must be entered today. The planning board will provide a recommendation for each rezoning request to the BCC, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communications outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, I'll ask if any board member has been involved in ex parte communication, and to please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code. The planning board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent, substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for a mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. A, consistent with the comprehensive plan, the proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 3, and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment transmitted for state agency review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, compatible with surroundings. All of the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by the fair housing laws. D, appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interests between the isolated district and the adjoining lands. And then criterion E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree in character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning. And the permitted uses of the proposed district are appropriate and not premature for the area, or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we will allow staff to briefly present the location and zoning maps of the photos and the property. Next, we will hear from the applicant and any witnesses that they may wish to call. Then we will hear from the staff and any witnesses they may wish to call. And finally, we will hear from members of the public who have filled out a speaker request form. And again, those are located in the back of the room. Today, we only have one case to be heard. And the rezoning application for consideration is case Z 2025-03, which requests rezoning of 7245 Bruner Street from MDR medium density residential district 10 dwelling units per acre to HDR high density residential district 18 dwelling units per acre as requested by Corey Parker, agent for Cereza Geiger, the owner. Members of the board, have there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
No to all. No to all.
No to all.
No to all.
No to all.
No to all.
No to all.
All right. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
All right. Was notice of the hearing posted on the subject property?
Yes, sir.
Okay. Mr. Parker, are you okay if we have staff present the photos and site plan? Okay. Thank you.
Good morning, Board. Allison Lindsay, Urban Planner. So these are the 2025-03 rezoning. This is the location map showing the site. This is the zoning map showing the parcel outlined in red for MDR, surrounded by MDR and an HDMU. This is the future land use map, mixed use suburban. And this is the wellhead protection area, the 20-year wellhead protection area. And this is the aerial photo of the site. This is the public hearing sign that was posted on site. And this is looking onto the subject property from across Bruner. This is looking across Bruner from the subject property. And this is looking northeast across Bruner from the subject property. This is looking east along Bruner. And this is looking west along Bruner toward Barone Street. This is looking at the apartment complex that's east of the subject property on Bruner. And that's the maps and photography.
All right, thank you very much. And since the boss has arrived, can we have the court reporter please swear in Mr. Jones?
You raise your right hand. Do you solemnly affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth? Do affirm.
Thank you. All right, now I'll have the applicant come forward and have you be sworn in. If you could just state your full name and address for the record for us, and we'll get you sworn in.
Raise your right hand. You solemnly swear the testimony you're about to give in this case or affirm will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State name and address.
Corey Parker, East Olive Road, Pensacola, Florida.
Okay, and then did you receive a copy of the rezoning hearing package with the findings of fact
I
from
did.
staff? Okay.
Yes, sir.
And then do you understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
Yes, sir.
Okay, I'll let you go ahead and walk us through, your application that you sent in to the county, and if you've gotten their findings of fact and agree with that too. You
Yeah,
can
I
state
agree
that
with
as well.
all what the staff had to say. The owner's desire is to build a duplex on the property. Initially, she wanted to submit for HDMU, but upon further review, there was uses that HDMU provides that we felt was really not necessary. And then the LDC, it says that HDR is a good transitional between MDR and HDMU, so we felt like that use was really the best fit for this, since we just want to do a duplex. And sewer's available, water's available, so it wouldn't be septic, and that was just the intended use for the owner. They'd like to do a duplex.
Okay. Are there any questions at this time for the applicant from the board? All right. Thank you, Mr. Parker, and we'll have you sit down. If we got questions, we'll get you back up here, all right?
Appreciate it. Thank you.
All right, staff, I'll have you go ahead and make your presentation at this time.
Okay, so this is the request for 7245 Bruner, and they're requesting to go from medium density residential at 10 dwelling units an acre to high density residential at 18 dwelling units per acre. Consistency with the comprehensive plan, the proposed amendment to HDR is consistent with the intent and purpose of the future land use for mixed use suburban. The FLU allows for residential and non-residential uses while promoting compatible infill development and the separation of urban and suburban lands. The applicant also has the right as a property owner to use, maintain, improve, and develop his or her property for personal use, subject to the state laws and local ordinances as stated in Chapter 17 of the Comprehensive Plan. Criteria B, consistency with the Land Development Code. The proposed amendment to the HDR is consistent with the intent and purpose of the Land Development Code due to the fact that HDR allows residential uses such as single-family, two-family, and also multifamily. The applicant is requesting HDR zoning designation for a 1.65 acre parcel. MDR and HDR zonings do not allow for retail sales or services, and they have the same uses such as in the public, civic, recreation, and entertainment and agricultural categories within the zoning district. The main difference is that the MDR allows for one single-family home on a parcel of land or 10 dwelling units an acre, and HDR allows for single-family, two-family, as well as multifamily at 18 dwelling units an acre. Compatible with surrounding uses. As per LDC 3-2.8, HDR is a transitional zoning for areas zoned or used for MDR and areas zoned or used for HDMU. HDR is compatible with the surrounding existing residential uses. The proposed zoning is a buffer between the HDMU, which has a multifamily, and the adjacent platted residential subdivision. The existing uses on the ground are residential and one multifamily development. Within the 500-foot radius area, properties were identified as MDR and HDMU. The proposed residential use will allow similar uses with a greater density than the current MDR. Appropriate if spot zoning. It was determined that the proposed HDR would be considered spot zoning. However, spot zoning is not by itself prohibited. The adjacent properties are already developed with single-family and one multifamily development along Bruner Street. Appropriate with changed or changing conditions. The established developments in the area have remained low-density residential. The request for high-density residential indicates that the potential uses, densities, and intensities allowed could be compatible with the existing surrounding development pattern. The proposed amendment would not create or contribute to urban sprawl. And also, the one thing that, as the applicant stated, he had considered the HDMU. So if you look at the HDMU zoning categories, actually rezoning to HDMU would be suitable where there were intermixing of uses and where future uses were uncertain. And in this particular case, the applicant wants to do residential uses. Also, with the HDMU, it's subject to locational criteria, which is more for non-residential uses such as commercial. And so he's asking for the HDR, so it is a good transition between the current MDR single family and then the HDMU, the existing apartment complex that has been there at least since 2011. Actually, I think it changed ownership in 2011, but it's been there for quite some time. And so, as you see the current map, MDR, the areas to the right, the HDMU, that portion at the curve of Bruner that's the existing multifamily apartment complex that has been there. And so the surrounding areas are single family, but this is a good transition so you don't have the intermixing of neighborhood commercial. And that's in the staff's analysis.
All right, thank you. Board, are there any questions for staff?
I do. I got simple, just, it might be having a brain fart or whatever, but MDR does not allow duplexes?
No, sir, sorry. So MDR, the old zoning of this was R2. If this had been R3, the two-family would have been allowed without even having to come to the rezoning. Even a conditional use would allow townhomes, but not duplexes.
All right, any further questions for staff? All right. So at this time, we'll move on to public comment. And I do have one speaker, Candace Smith. If you would, please come forward and state your name and address for the record and be sworn in, and then we'll get your time started.
Hi, I'm Candace Smith. I live at 7490 Barone Place. I just have.
And then I've
I'm
got to have
sorry.
you sworn in. Yes, ma'am.
Swear the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. The neighbors around me are mostly elderly and disabled. I'm the only one that was able to make it this morning, but we are all concerned with the added traffic that may come with this. We don't even know how many units they're trying to put in here because it says 18 per acre. That's a potential for 28 units. That's a lot of traffic on this street where children play. and a lot of noise. We already put up with a lot of noise from the apartments that are already there. We have disabled and people with anxieties and things like that on Barone Place back there. All that noise on the backside of our houses is going to be a big burden, plus the added point of we're going to lose property value with that on the backside of our houses. Nobody's going to want to buy a house with all of that behind us. All of the neighbors on Barone Place feel the same way. I'm just the only one that could come here and speak this morning.
Thank you. And were there any questions for our speaker from the board? No.
Can I make a comment?
Yes, ma'am.
So I do want to, the applicant was actually asking for a duplex, which is 2 dwellings. So it's 1 building and 2 units, 2 dwelling units. So even though this says 18 dwelling units an acre, that's if you were to develop it into a subdivision, that you could only have 18 dwelling units an acre. But this is 1.65 acres. And you're not going to get that density even if you wanted to go to something larger. But their intent was just to do 1 building with 2 homes.
Okay, that's why I came to get all the
Yes,
details
sir.
of
Yes,
everybody
ma'am.
else in the neighborhood so we can all have an understanding.
Yes, ma'am.
Yes, ma'am.
Okay, so it's gonna be one building, 1 duplex, so 2 families there. Okay, thank you very much. We all needed some clarification.
Let me, that is what he's proposing, but I do want to say for the record, if they do decide to do something else,
That was what we're
it
concerned
would,
about.
it definitely would be quite substantial for them to do that. But I really don't believe Mr. Corey Booker is going to come in and try to do anything different. But because now we don't have conditional use zoning,
Right.
so the HDR basic has the potential to allow for that. I want to be clear.
Right.
But if they do decide to do something differently, it will be there's another whole separate review process that will basically cause it to be more challenging to do that. So I want to be clear for the record in stating that.
Okay,
Quite substantial.
okay, so there would be more hearings before that could happen.
There's another whole complete different process.
Okay.
Absolutely, with more higher standards, more regulations,
Okay,
completely. So it just won't be, oh yeah, we're gonna do it.
Okay.
It's just not that simple.
gotcha.
Absolutely.
All righty, thank you very
Yeah,
much.
and thank you for coming down too.
Absolutely.
All right. Board, if there's no questions for staff, the applicant, or for our speaker, I will entertain a motion if someone would like to make one.
I'll move to make, to approve Z 2025-03 as presented.
All right, we got a
Second.
motion, got a second. Any discussion? All those in favor, please signify by raising your right hand. All those opposed? All right. Motion carries 5-1. I had to do some counting there for a second. All right. That is the only case we had today on the rezoning meeting, and so we will adjourn that, and we will now call to order the regular planning board meeting. The meeting of the Escambia County Planning Board for June 3rd, 2025 is hereby called to order. With 8 members present, we do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement. Do I have a motion?
Motion.
We got a motion. Do we have a second?
Second.
Second. All those in favor, please signify by raising your right hand. Motion carries. The planning board meeting minutes for May 6, 2025 have been provided to the board members. The chair will entertain a motion to accept the planning board meeting minutes into evidence. Do I have a motion?
So moved.
Got a motion? Do I have a second? All those in favor, please signify by raising your right hand. Motion carries. The planning board hearing package for June 3rd, 2025 has been provided to the board members. I'll entertain a motion to accept the planning board hearing package and legal advertisement into evidence. Do I have a motion?
So moved.
Do I have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed? All right. We have a public hearing today, a public hearing concerning the review of an ordinance adopting the 2024 through 2028 update to the 5-year schedule of capital improvements. and that the board review and recommend to the Board of County Commissioners, the BCC, for adoption an ordinance adopting the 2024-2028 update to the 5-year schedule of capital improvements for incorporation into Part 2 of the Code of Ordinance. Staff, will you go ahead and make your presentation?
Let me, and Allison Watts is going to do the presentation, but let me state it for the record. As you know, I think Walker been here, Mr. Spears been here, Mr. Rushing. What our job as the Development Service Department, when it comes to the capital improvement program, basically, we are just the gatekeepers. We just put everything together. We do not review the other department agency, what they submit to us. So if there's any other questions, being it's a public meeting, basically concerning a particular department, you can, Miss Rachel, she can take note of, because it's still open for the BCC for adoption, and they may pull until the department's list to discuss that. But as far as us having any of the specific answers to specific departments, we are just the gatekeepers. We just gather. Ms. Allison does a good job. We've always done that, and we just present it. But you definitely get your conversation noted, and we can basically relay them to other departments. That's all we can do at this point.
All right. Turn it over to you.
Okay, so there's really not much to say other than what Mr. Jones has said. This is a requirement, so every year we do an update. We send out notifications to our Office of Management and Budget, Solid Waste, Parks, Recreation, Stormwater, Traffic, all those, School Board, ECUA, ECAT. And so we gather that information, a lot of times not until they have had their final adoption budget, so they know, so they put their project list together, they provide it to us, and then their amendments and their ordinances and things their budgets get passed, and then they send us the information. So, like Mr. Jones said, we just compile it together and then provide it to the board for review.
All right. We do have one speaker signed up. I guess, are there any questions for staff before we move on to public comment? None? All right. We do have one public speaker, Mr. Chris Kerb. If you'll please come forward, state your name and address, and we'll get you going here. And good to see you.
Chris Kerb, live in Crescent Lake on the west side. I'm with Flood Defenders. Y'all have seen me up here before. I'll be real brief this morning, but the capital improvement plan is something that I've worked on every year for 25 years, just about, when I worked for the county. And I still work on it with Flood Defenders from a standpoint of giving input. And without going in specific detail, I'd like to turn your attention to page 6, the purpose of the capital improvement plan. It says a blueprint for future community dynamics, so not a static accounting document. But then it gets into why we're doing this for budgets and all that kind of stuff. And it says the CIP plan is developed to achieve most efficient financial planning over an extended period of time. Also goes in there and it says local government shall not issue development orders or permits which do not result in level of service reductions. Those are the two topics that I'd like to bring up. First of all, the numbers that you see in the budget for 25, 26, all the way up to 28, 29, they're actually based off of old estimates. Specifically in the drainage budget, because I actually prepared that in around 2018, 17 time frame. And the numbers get pushed forward when they don't get spent. But a lot of those numbers are based off of old estimates. I think it was last year's budget. It showed that there's an excess of $19 million in local option sales tax funding that's not allocated to projects. Wouldn't it be a good idea to update your numbers in your capital improvement plan and allocate those funds to projects? Because the numbers that are in the 2018 estimates that originally came up with all this plan, they don't reflect the reality of what it's going to cost. And this is a planning tool. So that's one comment that I wanted to make on record. I've asked this of the Board of County Commissioners at the last budget hearing last year. When are you going to allocate that $19 million to projects that are not funded adequately? Of course, you know, grants have been something good. Since my 3 minutes is up, I guess you can imagine the point I would make about local government not issuing development orders which do not result in reduction of service. I'll finish that another time. Thank you.
Thank you, Mr. Kerb. All right, are there any questions for staff? If not.
Just one.
Okay, go ahead.
Just curious, department to department, when they're preparing their CIP report every year to update the 5-year plan, is it the individual department's responsibility to calculate for escalation and inflation?
They do look at those projects, they do look at that. Now, how they do it, I do not know, and I do not want to speak without their knowledge.
So there's not someone centrally in control of budgetary facts that would apply an escalation or inflation factor?
I think what it says, it's a static document, it's flexibility, and those things are, of course, the economy is always a factor. It is static, the actual cost, and it goes back to how much money is allocated from those funds. So that's why it's static. So that's my limited, very, very limited knowledge on that. I do know that they do work with the budgeting offices and those different means. So it is static, it's fluid. So.
Anybody else have any questions? All right, if not, I'll entertain a motion if someone would like to make one.
Do we have a motion to make here, or is this?
Yes, sir, yes, sir. You definitely
Okay.
pass it on. It's required by the comprehensive plan, yes, sir, like we do every year. Yes, sir. And this is what I'm saying, and the board definitely is aware of it, pass it, get it to them. If they want more, they can call the subject matter expert like we do every year, and they can review it, they could talk to those individual directors on it. So again, our job is just to get it to them for the public meetings, and they could always have more commentary or more review. And if they feel like more information is needed from the department, the Board of County Commission, they definitely have that authority as well.
So I'll move to approve, since we have absolutely no authority or no say-so in this budget, I'll move to approve it and move forward.
Okay, got a motion and a second. Any discussion on the motion? All those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. We do have one more item, recommendation concerning the review of the comprehensive plan annual report 2023, 2024, the board review, the 23-24 comprehensive plan annual report.
Yes, so board, this is every year, we do this update, and we go through the different, we actually, if you look at the update, we don't have just this past year's, we've gone back and left the last 2 or 3 years in there for comparison. We do note all the cases we have between the Board of Adjustment, the Planning Board, all the DRC cases, all the AIPD cases. So we do just make this annual report as we update all our DRC projects and everything each year from each section of development services.
All right. And this isn't anything that we need to take a vote on, but if anybody's got some questions or,
My biggest thing is always housing affordability, and we have population trends, but we don't really have I'm not seeing a clear need for housing unit stock or anything like that in there. I mean, just in the future, maybe we can start adding something like that. Something to just show, hey, where our need is specifically in segments. Like I said, there is affordable housing in there, but maybe for a little bit more emphasis on the workforce housing, so.
Okay.
all right, anything else? All right, thank you guys. Well, there's no anybody here from the public to forum with us, and anything from staff, county attorney, director. All right, well then, let's see, our next meeting is July 1st, so don't let that sneak up on you. It's always
Please.
fun when it's the first of the month.
Please be here. We're gonna have a development agreement, a planned unit development, a rezoning, and 2 small scales.
All right.
So just emphasize that, yeah, it's quite critical. It's quite critical. If you're not gonna make it, please let Ms. Rachel know, because those are legal documents, in public meetings, and we must have a quorum. And I'm quite certain it's gonna be rather extensive and rather labor intensive.
Great. So we'll see you on
Bring your
July
coffee.
1st. And Horace said that you can have that Friday the 4th off, so. Or adjourn.